Hola, how you doing today? This is Adam Ouellette. I'm an attorney here in South Florida. I've been an attorney for the past 15 years, and I wanted to bring you some information about complaints and protecting your license. I have an opportunity every couple years to go to my continuing education for my license to teach real estate school. And every time I go to this, they give us different information on the latest complaints and what's on the top of the list for complaints from consumers about real estate licensees. So get ready for a few minutes here. It's going to be about a 5-minute web video. And I'm going to give you the latest information that I have from the head of the DRE, who's also an attorney, and what she told me and told us at the workshop CE that I went to. So the tops of the list right now are clearly short sales, if you can imagine that. Part of the problem with short sales is it's relatively new, and the biggest issue that they're finding as far as complaints is pricing of the property. So you take a listing and the short sale seller is in foreclosure, and the time frame for the foreclosure is getting tight, which means the property may be sold at auction, or the foreclosure itself is getting to the point where it is in a state where it's getting towards the end. When it comes to this kind of issue is pricing it as best as you can. You got to have enough time to get to the point where you can get a short sale approval. So a lot of questions come to us asking, should I even take this listing? And it's a case-by-case basis, but you do open yourself up to complaints if you can't get this thing done in time. They look to you, which is pretty ridiculous, but they still do, because they thought you should have been able to get it done timely, this, that, and the other. So it's real important to price it correctly no matter where you are in the process. If you price it too high, it takes too long to sell, and the foreclosure goes through. You may get a complaint there. You price it too low, you get a buyer in that is willing to pay a lot less than market value, and you spend a lot of time waiting for the lender to approve the short sale, and you get a price back that's closer to market value with their BPO, and you've wasted a lot of time there too. So just be real careful pricing short sales. The second issue with short sales and complaints is processing short sales yourselves. I don't recommend this for anybody, and there's a lot of reasons for it. The timing is always a concern. Basically, you're just going to be collecting documents if you're doing this, and you can't negotiate. So if you can't negotiate, you have your hands tied with what you can do. And the other problem that you have is a lot of this requires giving some sort of legal advice to the sellers as far as what to do when you get an approval letter, if you get one, and the consequences of accepting such approvals based on whether the lender is going to require them to sign a note, whether they reserve the right to pursue them on a deficiency or anything like that. When you advise them, you get into the bounds of practicing law, which we're going to talk about the unauthorized practicing law for a short minute or so in this video, so stay tuned. Can you charge a fee? No, you can't. You can only get paid commission, and that's it. I've had a lot of realtors call me and say, well, you know, I'm doing this work, I want to get a fee. Well, you can't. There's no way to do that legally. And some people say, well, I see these other guys doing it, and that doesn't make it okay. So you cannot charge a fee. And then the last thing on processing short sales is whether there creates a fiduciary duty by you doing this. I think that remains to be seen what happens with this, but I think the problem is you do create some sort of fiduciary duty which raises the level of services that you have to provide and causes complaints. So I suggest you leave processing of short sales to title companies or attorneys. I mean, clearly I'm an attorney. We do the processing in our office through our law firm because we want to be able to negotiate for those sellers if the lenders come back and want to create deficiency situations and stuff like that. But if I were you, I'd stick to listing and selling and not to processing short sales, because that is number one complaint going now. What else is at the top of the list? culpable negligence is a big one, and that's breaching a duty imposed by 475 or any other law that's placed on you as a licensee. We're going to get into this in a lot more detail in a future web video, so stay tuned for that. But ultimately, you have to do what you say you're going to do, and you have to do what the law requires you to do. Next, we talked a little bit about it before, unauthorized practice of law and or giving tax advice. You got to be real careful with the opinions you give, because a lot of it will fall within the practice of law and what an attorney is allowed to advise people on. The other thing that I see and have heard about as far as complaints is realtors giving tax advice to sellers as to whether they're going to have any kind of tax liability after the short sale is completed with the IRS. I take it as far as I don't even give that advice, because I'm not a CPA or an accountant, and I don't know the tax law. So I tell people you got to get an opinion from your CPA. The other big issue, and it always has been, and it probably will be and continue to be, is the deposits on a contract. Well, what does that mean? Well, if you are representing, and I don't even want to say representing, but you're the customer is the buyer to you. People say represent all the time, and it really isn't the case. But if your customer is the buyer, then you have a duty to make sure that you get those deposits, and if you don't get them, at least you have to remind them multiple times via email and phone, and make sure you document this stuff, because it's a biggie. To get that money when you get it from the buyer to the title company, to your escrow agent or your broker, whoever's holding the escrow, you're going to make sure you get that to them within the time required by the law. It's not a lot of time. So if you have an additional deposit, you need to make sure that you remind them in plenty of time to get that additional deposit over to you, and you get that to wherever it's supposed to go. And document this stuff. You have to document it through email, which I think is the best at this point, because you have something in writing that you sent them reminding them. So you can't force anybody to give you a check, but you can remind them, and under the law, your duty ends there. You know, you can't go over to somebody's house and say, you've got to give me a check. No. It's got to make sure that you comply with the deadlines that you are required to comply with. Ultimately, in the end, we're probably going to have an hour-long workshop on these kinds of topics, especially with deposits. And it is part of my FAR workshop series, which I'm doing on webinars, and also we'll have some more stuff on online here with web videos soon. The other contract deadline stuff is inspections. You got to make sure that they know the deadlines for the inspection periods, and that they have to give their cancellation notice, if that's going to be what happens, timely. Mortgage financing is a little bit unclear as to what your duty would be, but ultimately in this, you should remind them that they have to make loan application within 5 days, and that they have a duty, or whatever it says under the contract. Most of the time it says 5 days. And the other part of it is to have the loan commitment issued within a certain number of days based on the contract form. And it's good to remind them of this stuff so that they know that there are these deadlines. And lastly, their closing deadlines. If they're getting close to the closing date and they don't have their loan commitment, it's important to remind them that they should probably get the advice of an attorney if it's going to be a problem, because their deposit is at issue at that point, and when you get close to that closing date. So it's important that they know what's coming, and that you tell them. If you need an attorney, you need to go get one. They have a right to one. It's not always needed in every instance, but if their deposit becomes an issue, then they need to talk to somebody to give them some legal advice. So thanks for watching. I invite you to give us a try on your next closing if you don't use us already. We will be doing a lot more of these videos. Check out and join on our Real Property U website to have free access to all of the content that I'm providing. I'm doing at least 2 to 3 to 4 videos every week. And there's going to be tons of content for you, your buyers, your sellers, and anybody interested in short sale information. Again, this is Adam Ouellette, and I appreciate your time, and have a great day.